Hey guys, welcome to this video. My name is John Watts. I'm a consumer protection lawyer. This is a case from the 11th Circuit Court of Appeals involving the FCRA, Fair Credit Reporting Act case. And really the major point of this case for our purposes is it explains the difference between negligent violations and willful violations. And also explains when a consumer, a plaintiff, has abandoned a negligence claim, and kind of what the significance of that is. So let's look and see what we have here. So the consumer sues Quicken Loans under Fair Credit Reporting Act and says, well, look, you violated the FCRA either willfully or negligently by failing to send me a credit score disclosure. So that's a CSD, after using my credit score in connection with my spouse's inquiry into a joint mortgage loan. So let's sort of stop there. We've got a consumer saying, look, my husband applied for a loan. This was going to be a joint mortgage loan. You used my credit score, but you did not send me a disclosure that you had done that. And so I believe that violates the Fair Credit Reporting Act. So the district court grants summary judgment. So that's typically after all discovery has taken place. And the next step would be trial. But here the court said, well, I'm entering judgment in favor of Quicken for a couple reasons. One, you did not provide sufficient evidence of willfulness and you abandoned your negligence claim. Well, the consumer says, I got three arguments on appeal. First, the court erred by finding that the interpretation by Quicken was objectively reasonable. This has to do with willfulness, and we'll get into this because it's a little odd how the FCRA has been interpreted to figure out when a violation is willful. So that's number one. Number two, the court made a mistake by excluding certain emails. And then number three, the court erred by saying the consumer had abandoned her negligence claims. Now, the 11th Circuit says we agree with the district court judge as far as the result. So let's look at this abandonment. If a party fails to adequately brief a claim in responding to a motion for summary judgment, we will consider that claim to have been abandoned. So you give up on that claim. So when do you fail to adequately brief? Well, when he or she does not plainly and prominently raise it, such as by devoting a discrete section of the argument to the claim. So sort of passing references, or you bury the argument in the middle of something else, that's not going to suffice. So we'll come back to that in a moment. So let's see what the law says. The FCRA places certain disclosure obligations on entities who use consumer credit scores in the course of their business. So that's what we're talking about here. So it's 1681G of the FCRA. So any person who makes or arranges loans and who uses a consumer credit score in connection with an application initiated or sought by a consumer, and that'll be a big deal here in a moment, for a closed-end loan. So closed-end is like a car loan, a student loan, a mortgage loan. It has a fixed period of time, 30 years, 6 years, whatever. It's different than a credit card. All right, so if we have a company that uses a consumer credit score with an application initiated or sought by a consumer for a closed-end loan shall provide the CSD to the consumer as soon as reasonably practical. All right, so anyone who willfully fails to comply with this requirement is liable for a compensatory, that's to compensate you, to make you whole, and punitive damages to punish the company that violated the law willfully and to deter or discourage them and other companies from doing the same thing. Now, what if it's a negligent violation? Well, then you only get those compensatory or what are called actual damages. So there's no punishment involved. So they say, well, let's look at willful. You say, well, why wouldn't we start with negligent? Well, they're going to say that that claim was abandoned. Okay, so, and the reason I want to see this opinion is really to see what does the 11th Circuit, which is the federal appellate court over Alabama, Georgia, Florida, how does it define willful? So to prove a willful violation, you must show the defendant either knowingly or recklessly violated the requirements of the Fair Credit Reporting Act. Well, how do you do that? Well, a defendant does not recklessly violate unless its interpretation was objectively unreasonable. Well, what does that mean? Either under the text or under guidance from the Court of Appeals or the FTC. Okay. Now, that would probably also be now the CFPB. Okay. Consumer Financial Protection Bureau. Where a consumer fails to show the defendant's reading was objectively unreasonable, we will not look at evidence of the subjective intent. So the company could have all sorts of memos and videos saying, yep, we know we're violating the law, we're horrible people, we admit it. None of that matters because that's subjective. We're looking at objectively, was this reckless? And so we either have to see that based on the text or a Court of Appeals opinion or a governmental agency. So here, the 11th Circuit says District Court did not err by dismissing the willful violation because she failed to demonstrate their interpretation of its FCRA obligations was objectively unreasonable. So remember, the deal is you have to do a CSD, that disclosure, whenever they use a consumer credit score in connection with the loan application initiated or sought by the consumer. So there's two categories of consumers according to the 11th Circuit. Number one, the consumer whose credit score is used, and number two, the consumer who initiates or seeks an application. So it doesn't make it clear, this is what the district court found, doesn't make it clear which type of consumer is, quote, the consumer entitled to a CSD. Is it the one whose credit score is used? That's what the consumer was saying here. Or is it the consumer who initiates or seeks an application? Okay, so that would be the husband because the husband sought this. And they say, thus the text of the FCRA, because remember, if we want to know if something's willful, we first look and see, did it violate the text or a Court of Appeals opinion or a governmental agency? They say, thus the text does not foreclose, does not say, hey, Quicken's reading is crazy. Okay. Now, in this footnote, it says, she argued because it's a joint mortgage loan, she too qualifies as a consumer who initiated. And then they say, well, that may be one reasonable reading. We cannot conclude it's the only objective reasonable interpretation. Okay. So now let's go back to the main part. So they say the text of the FCRA does not give us the answer, nor has the consumer pointed any guidance from this court, the 11th Circuit Court of Appeals, or the Federal Trade Commission that should have warned Quicken away from the view it took. And they say, we've never addressed or construed this particular subsection in any of our decisions, published or unpublished. I talked about this last time. A lot of times you'll have these, quote, unpublished decisions. It just means they're not supposed to have the same authority or weight that a published decision would. But I said as a practical matter, it doesn't make a whole lot of difference now. And here you see the 11th Circuit, who, if I remember right, the rule says we're not even really supposed to cite these unpublished decisions. They're saying, well, look, we've never talked about this in any of our decisions, published or unpublished. And by the way, judges often cite to unpublished decisions. So then similar, the FTC does not appear to have issued any authoritative guidance on this question. So the question is it the consumer whose score is used or the consumer who applied for the loan? And so they say, thus the consumers failed to show that Quicken's interpretation was unreasonable. And then there's some guidance here that she argues. And then they say, well, look, we don't offer any opinion on the proper interpretation. Okay, we just say it wasn't unreasonable. And so the district court did not err by refusing to consider the internal emails, because if you don't establish that it was objectively unreasonable, then we don't look at the defendant's subjective motives. Okay. Well, what about, if you're following along this video, you're probably like, well, tell us the answer. Like, which one is it? Is it the consumer whose score is used or the consumer who initiates or applies for the loan? Well, we don't get that answer because the court ruled that the consumer abandoned their negligent violation. District court did not err in concluding she abandoned her negligent violation. Devoted only 3 sentences to her argument that Quicken had negligently violated the Section 1681G. Those sentences essentially stated, without any citation to authority, the evidence demonstrating willfulness was also sufficient to support a negligence-based claim. And they say that's not enough to preserve the claim, and the argument fails because it does not establish we're objectively unreasonable. Now, that last sentence doesn't particularly make a whole lot of sense if they were looking at this from a negligent standpoint. They would have to tell us either yes, Quicken violated the law, or no, Quicken did not violate the law. Now, they might say they violated the law, but it wasn't negligent, but at least we would get an answer. Right now, we don't know what the answer is. But I wanted you to see this opinion mainly for that willfulness, because this is a little different than other laws. Here they're looking at, is it objectively unreasonable, which it could totally be objectively unreasonable just based on the text of the statute. So let me give you an example. The statute says, and we have this all the time, where you dispute information that you think is inaccurate or incomplete, and you dispute to the credit bureau, then the credit bureau gets that, and they have to notify the furnisher of your dispute, and they don't do that. Well, to me, that's very clear that that's a willful violation of law because it's unreasonable. The text itself says you have to do this, and they just ignore it. Now, they might say, well, but did anybody give us any warning this was wrong? Yeah, Congress did. It's in the statute itself, okay? But here, if we go back to this statute, that a consumer credit score in connection with an application initiated or sought by a consumer shall provide the disclosure to the consumer. Here the court's going, well, it's kind of ambiguous. What do we mean? But if it's not ambiguous, then that settles the question for willfulness. So hope you found this useful. I'll continue to do these case decision videos as long as you guys get value from this. So let me know if you like these. Let me know your thoughts about this. What do you think about this opinion? What do you think about this unanswered question, which is, should it be the person whose score is used or the person who initiated the transaction, or should it be both? What do you think about this? So you guys have a fantastic day, and I will talk to you tomorrow. Thanks a lot. Bye-bye.